Today, Norway's Supreme Court handed Jehovah's Witnesses a victory. 3 judges against 2 ruled that the state cannot deny the organization its registration or its public funding. 100 million Norwegian kroner, roughly $9 million, will now flow from taxpayers directly into the Watchtower's accounts. The fight that began when Norway became the first Western democracy to strip this organization of state recognition is over at the national level. They won. But how they won is a story every current and former witness needs to understand. Because they did not win by proving they are right. They won because of a fatal flaw in Norwegian law and a courtroom strategy built on presenting a version of this organization that anyone who has lived inside it knows is fiction. 2 of the 5 justices refused to sign the majority opinion. One of them wrote a dissent that reads like a letter to every child who was ever pressured into baptism. By the end of this video, you will know exactly what that dissent said, how the Watchtower's legal team manufactured a false reality inside that courtroom, and why this so-called victory may turn out to be the worst thing that ever happened to them. Part 1. Inside the Supreme Court. In February of this year, former Jehovah's Witnesses traveled from the United States, Spain, Iceland, Denmark, and Finland to sit in the gallery of Norway's Supreme Court. The line to get inside stretched out the door. Only 2 or 3 former members managed to get seats. The rest of the gallery was packed with active witnesses. The hearings were live-streamed. Thousands followed in real time around the world. For 3 days, the highest court in Norway examined one question that the Watchtower has spent decades avoiding in public. Does this organization's shunning practice violate human rights? The state's attorney, Liv Inger Gjone Gabrielsen, laid out the case directly. She told the court that when Jehovah's Witnesses describe their own practice, they refer to their own texts. Those texts describe expulsion as a loving arrangement and instruct members to avoid those who leave. She argued that the social consequences of leaving are so severe, particularly for people baptized as minors, that members are not truly free to walk away. She argued that this constitutes both a violation of children's rights and undue pressure against free withdrawal. Then came the Watchtower's defense, and this is where the courtroom became a stage. Their attorney, Anders Risdahl, did not spend his time defending the theology of shunning. He spent it presenting a carefully curated version of life inside the organization. He brought active witnesses to testify one after another. One mother told the court her children attend regular school, have friends outside the faith, and maintain normal relationships with non-witness relatives. She said her children had not yet chosen baptism and were free to decide at their own pace. Another witness described growing up in a mixed-faith household where becoming a witness was entirely her own choice. A father whose daughter was disfellowshipped at 18 testified that family relationships remained intact, that they continued supporting her emotionally and practically. Risdahl told the court that family ties are not broken by expulsion. He said that no one worries about being excluded. He insisted that Jehovah's Witnesses do not even use the word shunning and that it misrepresents their practice. Jan Frode Nielsen sat in the front row listening to all of this. He is the former member who has testified against the organization 3 times across 4 years. He later said he wanted to stand up and scream, "That is not our story. That is not my experience. That is not my life." The state tried to counter this. Gabrielsen presented a document from the Watchtower's own website, directly linked to a video previously shown in lower courts, a video entitled, "Loyally Uphold Jehovah's Judgments, Shun Unrepentant Wrongdoers." That video has since been deleted from the organization's website, but the document connecting to it was entered into evidence. It did not matter. On April 30th, the verdict arrived, 3-2. The Watchtower won. Part 2. The logic that should disturb you. The ruling came down to 2 questions. Does shunning violate children's rights? And does it create undue pressure that prevents members from leaving freely? On children's rights, the decision was unanimous, 5-0. The court said the state had not proven that the organization subjects minors to psychological violence severe enough to cross the legal threshold. But listen carefully to the reasoning. The majority noted that most baptized members are over 15, which is the age of religious majority in Norway. For those under 15, the court wrote that no evidence had been presented to suggest their decision to be baptized was not based on informed and independent choices. Then came the sentence that should stop every person watching this. The court stated that it must be assumed that the minor is also aware of the consequences of withdrawing or being expelled from Jehovah's Witnesses. Think about what that sentence is doing. A child raised from birth inside a system that teaches any outside information is spiritual poison. A child taught that doubting the governing body is doubting God himself. A child told that people who leave are under the control of Satan. A child whose only permitted reading material about their own religion comes from the organization itself. And the highest court in Norway looked at that child and said she made an informed and independent choice. They treated a teenager being baptized at 14 the same way they might treat an adult signing a business contract, aware of the terms, accepting the conditions. One commenter on the ex-witness community put it perfectly. "I understood what it meant, but I did not have the capacity to imagine it would ever happen to me. I was a good little witness child. I would never make Jehovah sad by leaving. Never. I did not know what I did not know." That is the difference between understanding consequences in theory and being able to make a free choice. A child inside this system is taught that even thinking about leaving is a betrayal of God. Leaving is literally unthinkable, not because they weighed the options and decided to stay, but because the system never allowed the options to exist in their mind in the first place. The majority also praised what it described as a more considerate approach toward minors in recent years. These are adjustments the Watchtower made to its discipline procedures for younger members. Changes critics argue were made specifically to improve their legal standing in cases exactly like this one. The court rewarded the strategy. On the second question, free withdrawal, the court split 3-2. The majority concluded that while shunning clearly has serious social consequences, including the potential loss of every family relationship a person has, it does not rise to the level of undue pressure. The reasoning was that members who join are already aware of the rules, so the consequences of leaving cannot be considered a surprise. The Watchtower's curated witnesses did their job. The majority accepted the picture of a tolerant community where leaving is a personal choice with manageable consequences. 3 justices believed what Anders Risdal put on that stage, but 2 justices did not. Part 3. The dissent that saw through it. Justice Poulsen wrote the minority opinion, and it dismantles the majority's central argument with a single paragraph. The majority had said that because members know the rules when they join, the consequences of leaving cannot be considered undue pressure. Poulsen rejected this directly. She wrote that precisely because many relinquish rights and freedoms by being part of a religious community, it is all the more important that it is possible to reclaim these rights and freedoms by withdrawing. Then she added 4 words that cut to the center of everything. This is particularly true for children. Read that again. The majority said children knew what they signed up for. Poulsen said the opposite. She said that because children give up the most, they deserve the strongest protection when they try to leave. The minority found that contact with former members changes and is reduced to such a degree that the right to free withdrawal is violated. 2 Supreme Court justices examined the Watchtower's own publications, heard the testimonies of people who lost their parents, their siblings, their entire social world, and concluded that what this organization does to people who leave is not a private religious matter. It is a violation of their fundamental rights. The minority also argued that the threshold the majority set was far too high. In their view, Section 6 of the Religious Communities Act should not require the state to prove extreme harm before it can intervene. The point of the law was to create accountability. The majority's interpretation, they said, makes that accountability nearly impossible. And this is where the real story of this ruling becomes clear. The Watchtower did not win because the Supreme Court endorsed shunning. It won because the law that was supposed to stop organizations like this was written without teeth. The terms psychological violence and negative social control have no precise legal definition in Norwegian law. The court had no established framework to measure them against. Jan Frode Nielsen said it plainly after the verdict. This is about terribly poor drafting in the Religious Communities Act. It is too vague. The Watchtower's lawyers understood this from the very beginning. They did not need to prove that shunning is harmless. They only needed to show that the law could not clearly define the harm. And 3 judges agreed. So the Watchtower has its money. It has its registration. Its leaders will stand on convention stages and call this divine vindication, proof that Jehovah protects his organization. But consider what this case actually cost them. For the first time in history, the internal discipline machinery of Jehovah's Witnesses was examined by a nation's highest court under full public scrutiny. The hearings were live-streamed to the world. The court record now contains detailed survivor testimony describing the systematic severing of family bonds. Testimony the Watchtower's own attorney dismissed as isolated and exaggerated, while a deleted video from their own website sat in the evidence file. 2 Supreme Court justices have now written, in a formal legal opinion that will exist for as long as Norwegian law exists, that this organization violates its members' right to leave. That language does not disappear because the majority ruled differently. It becomes precedent for every future case. The state's own attorney said after the ruling that the ministry and the county governor will now begin work to prepare new decisions that follow up the judgment. The law will be rewritten. The definitions will be sharpened. Sweden has already moved against the witnesses on the same grounds. Other European governments are watching and taking notes. Jan Frode Nielsen stood outside that courthouse at 5:50 in the morning on the last day of hearings. He had been fighting this for over 5 years. He said he speaks for those who lie like dead meat on the side of the road because they cannot cope with life after everyone they know disappears. Today, he said he was saddened but not surprised. He called the process extraordinary. And he is right. Because this case did something no amount of money can undo. It put a permanent light on what this organization does to the people who try to leave. The money is back in their pocket. But the light is now on their practices. And lights, once turned on, do not turn off. If this case affected you, if you recognized your own story in what that courtroom heard, share this video. Not for the algorithm. For the person still inside, who has not yet found the courage to search for what they are not supposed to see. The next legal battle is already being prepared. And the evidence that will win it is your story.